Okay, we're here today with attorney Steve Okey, and Steve just filed a lawsuit on February 4th in which he alleges violations of Ohio's Sunshine Law. And Steve is going to elaborate for us as to the background of bringing this lawsuit and provide us with some specifics as to why he felt compelled to go forward with this litigation.
Well, Martin, really the purpose behind my filing this civil action is to expose the improper practice of secret ballot votes in Alliance City Council, and also to prevent it from happening again in the future. It's an issue that's of importance because knowing how your representative votes on whatever issue may be before your representatives is really central to our democracy. If you don't know how your representative voted, you don't have a way to evaluate their conduct in office and their decision-making process. So I think it's an important issue, and it needs to be brought to the forefront.
Now, the allegations in your complaint include two incidents, one back in 2012 and one just here on January 13th of 2014. And we need to point out to the viewing public that you yourself are a former Alliance City
correct.
Councilman. And so would you just so we know the time frame as to when these incidents occurred and your own stay on Alliance City Council, how they dovetail with one another?
Sure. I was elected 3 times, so I served a total of 6 years, and my term began January 1 of 2006 and concluded, my third term concluded December 31st, 2011. So that was a period of this 3 full 2-year terms.
And the occasions that your allegations that violations of Sunshine Law occurred was after you were off council.
That's correct. That's right.
Now, were there any incidents before 2012 when you were on council where there were secret ballot votes with the Alliance City Council?
Before I was off City Council, for almost the entire period of my 6 years, the Attorney General had not yet issued his opinion stating that secret ballot votes were improper. And as I look back, there is an occasion that I can remember, and I think that it related to the appointment by City Council of the council clerk. And I think there was one occasion, there might have been another one, but off the top of my head, I recall that one where it was, I believe, a secret ballot vote relating to the appointment of the council clerk, and this was probably back in early, probably 2006. Is the one that I recall. And that was during a time where the Attorney General's opinion in force and effect at the time was that it was okay. So that changed, though, in October of 2011 when Attorney General Mike DeWine issued the current opinion and directive indicating that secret ballot votes are clearly a violation of the Sunshine.
But the effect of that vote, even though there wasn't an Attorney General opinion, it was the same as now, that the general public just doesn't know how council persons vote.
That's the whole problem with secret ballot votes, is that someone from the outside, a member of the public, can't know how their elected representative voted on that particular issue. There's no way to know. It's just subject to guesswork, and that's not an open meeting in all respects.
Now, but you made no objection, and no other council person made an objection on the at least one occasion that occurred before the Ohio Attorney General's opinion of October 2011.
Correct. At that time, the Attorney General opinion that was in effect had indicated that it was not inconsistent with the Ohio Sunshine Law. And that's an Attorney General opinion from a number of years ago, and I think it related to the State Board of Education. So that was the one that was in effect at that time, correct.
Do you have a recollection of whether or not in your heart of hearts, you had any misgivings about that particular vote?
As I sit here today, I don't. As I look back, I don't have any specific memory, Martin, of a thought process that went through it at that time. Okay. I may or may not have. I just don't remember as I sit here today.
You, of course, are a person that's been politically active in Stark County. Mm-hmm. In addition to running for and being elected to Alliance City Council for 3 terms, it was.
That's right.
As a Democrat. You also ran for mayor in what year was that?
That would be 2011.
As a Democrat?
Yes, that's correct.
And, of course, you're going to catch the flack and fire of Republicans. And I, of course, have had input from Republicans suggesting to me that your lawsuit was inspired not because of Steve Okey's devotion to the Sunshine Law, but because Steve Okey has a political axe to grind. And so how do you respond to that?
It's not true. I've been politically active, and I am a Democrat, but you'll see in this lawsuit, which I know that you've read, and which is public record, the lawsuit includes defendants who are Democrats as well as Republicans. It's not just a partisan issue. Open meetings and the Sunshine Law is a nonpartisan issue. It cuts across all political divides, and so the fact of the matter is that Republicans as well as Democrats were involved in the improper secret ballot vote, and they're included as well, both sides, in this lawsuit. Now, I note that Council President, a Democrat,
Benincasa, was not included in the reason for that?
Council President John Benincasa was not included because under Ohio law, the Council President for a statutory city is actually part of the executive authority. They're part of the executive branch. He's not a part of City Council. He has a council president. He presides, but he is not a member of the legislative branch. So the legislative branch is an independent branch, and it alone is responsible for its votes. If any 2 members of City Council under council rules can override or can ask the council to override any point of order by the president. So the City Council has its own responsibility, its own authority under state law. Council President John Benincasa is not a part of City Council under state law, and I think it's Revised Code 73301. That's off the top of my head. I might be wrong on that, but I think if you look it up, you'll see it in that area.
So, council itself, let's say, and I think you, in your allegation on the 2012 incident, that Council President Benincasa asked for the secret ballot. So your rejoinder would be, well, 2 members of council could overrule that and say, no, we're not going to do a secret ballot, or at least ask the rest of council
Correct.
To override that. Let me put it that way.
Correct.
Am I correct in that assessment?
No, you're correct. Any 2 members under City Council rules, any 2 members of council can ask council as a whole to overrule the president regarding any matter, any point of order. And so if the president asks City Council to do something that would be improper or directed them, council has full authority to say, we're not going to do that. So they have their own independent responsibility and their capacity to make sure that they're in compliance independently of the president of City Council.
Now, I noticed that Councilwoman Phillips is not a part of the lawsuit either. What's the reason for that?
I included the members of council, current members of council who voted in the improper secret ballot vote, or current members of council who have participated twice in it, both in 2014 and back in February of 2012. Councilwoman Phyllis Phillips was absent. She was unable to participate in the January 2014 vote, so I did not include her. I also did not include former Councilman Roy Klunk, who's no longer a public official, and he had participated back in 2012, but he's not currently a public official.
Right. So he participated in the 2012 vote, correct?
That, to my understanding, yes, according to the minutes.
How about Councilwoman Phillips? Did she participate in that?
To my understanding, yes, but again, I included the members who are current council members who participated in the current vote, or have participated in 2 votes. So just this one single incident, I elected to keep those folks out.
And you stand by your word that excluding her has no political motivation
No political motivation whatsoever. No, she wasn't there to vote.
Now, the 2014 incident involved a member of the Alliance Sewer and Water Board?
Water Sewer Advisory Board.
Okay.
Yes.
And Derek Loy.
That's correct.
And one of the things I'm hearing from your detractors is that he has a political relationship with you. The allegation is, and you know, of course, better than anybody else, that he was your campaign manager when you ran for mayor.
He was not my campaign manager. He worked with me on my campaign. I don't think he had the title campaign manager, to be completely accurate. But he did work with me on my campaign, and I've known Derek for a number of years. And
of course, another suggestion being made to me along the political lines is that you have an indirect relationship with the contest that's going on in Stark County over who's ultimately going to be the Stark County Sheriff. On your side, you've been supportive of the candidacy of the Stark County Democratic Party Central Committee appointed Sheriff George Meyer, and of course a member of Alliance City Council, and the defendant in your lawsuit is Larry Dordia, who's filed to be the Republican candidate. And I guess to kind of bring in another factor, Mr. Loy, as I understand it, works for Sheriff Meyer.
He does. That's correct. And
how do you address all these?
Well, you have a lot of goings on in local politics at this period of time. A lot of the cast of characters have overlap. The timing of this lawsuit that I filed, though, Martin, has nothing to do with the sheriff's race, because the timing of this lawsuit was dictated solely by the statute of limitations that's set by the Ohio Revised Code. And the statute of limitations in the statute is 2 years from the alleged violation. Well, the 2 years for the 2012 event, illegal vote, was going to run on February 6th, 2014. So if I did not file it at this time, then that violation of the Sunshine Law would be discharged by the passage of time. So I had no choice to include, if we were going to include that violation, I had no choice but to file it before February 6th, 2014, because the statute of limitations was going to run. I'm not a member of the Central Committee, so I cast no vote for who would be appointed sheriff. I did represent the Democratic Central Committee and the chairman, Randy Gonzalez, in the quo warranto action that was filed by Mr. Swanson and Mr. Darrow.
Was it quo warranto or mandamus?
Excuse me, it was the mandamus. Thank you for correcting me. There's been so many lawsuits that sometimes you trip over your own words.
I understand.
It was the mandamus action, correct. And I represented the chairman and the Central Committee, and I did not make a public statement for or against at the meeting for or against any candidate. In fact, I gave my opinion that all of the candidates, it would be Sheriff Meyer, Lieutenant Darrow, Hartville Police Chief, Larry Dordia, and the deputy, I think, Smith, from Summit County, that all 4 of the candidates were qualified. So I included Mr. Dordia. I felt that he was qualified under the statute to sit and be considered for the appointment. So, and Mr. Dordia, of course, was not a party to that mandamus action. So there is overlap of the characters, but the timing of this particular lawsuit relating to the Sunshine Law violations was controlled solely by the statute of limitations that the statute set in. There was really no choice but to file it before February 6th.
Okay. Now, in setting out your complaint, I do notice that you named Larry Doherty as the first defendant. Is there a
Correct.
reason for that?
There is a reason. He's pro tem of City Council, so he has a position. He's the senior leadership position of City Council, and as the president pro tem, I named him first. I named the majority members. City Council is currently controlled by the Republican Party, and they, as the majority, they can control and dictate the agenda and the votes. So I think pretty much that dictates that they would be named first. And I named Mr. Doherty first as President Pro Tem, and then the at-large members, and then the ward members, and then I did the same for the minority members of City Council who are defendants.
Now, I have talked to Mr. Doherty before I came here,
Yes.
and one of the things that annoys him quite a bit is that throughout the lawsuit, and I understand why attorneys do this just in general, but he's annoyed by the fact that you refer to the defendants pretty much by his name. Do you have a response to that?
There are two general sets of defendants. There's the individual City Council members who are defendants, and there's 6 of those. And then there's the City of Alliance defendant. It's a separate defendant. Each time, and this is a shorthand that attorneys use when we draft complaints, right. If you have a number of named defendants, in this case 6 individual, rather than naming them each individual, Larry Doherty, Julie Giacomides, Roger Rome, Don Klein, Phyllis Phillips was not included, but Sue Ryan and Sheila Cherry. Rather than naming all those 6 people, you shorthand it by usually the first named defendant, in that case, Mr. Doherty. So I put in parentheses, hereafter referred to as the defendant's Doherty. Mm-hmm. So that's just a shorthand to indicate that's inclusive of all 6 of those individual members. And that's just a shorthand that we use in when we're drafting complaints and really all legal documents, to avoid the burdensome repetition of a number of string of names. It's just not necessary.
Okay. And I assume that you're ready to tell me that there's no political implication in that. You're not trying to lay it at Doherty's door to the exclusion of other council people who voted on the secret ballot.
All 6 of the individual members of City Council are all individual defendants in the case. Mr. Doherty, he's the president pro tem. He accepted that position. It's the senior position of leadership of City Council, and therefore, recognizing that seniority, I named him first. That's the only reason.
Okay. One thing that we haven't covered is going back to the procedure. Is there something in Alliance City Council rules that provide for secret ballot?
I've not really looked at the City Council rules and scoured them as it relates to whether there's a provision in there about secret ballot votes. It would be my opinion, and again, I'm just speculating whether there's anything even in there that would be improper under the Sunshine Law. I think it would be a violation of the Open Meetings Act if it would be in there. But again, I haven't reviewed the City Council rules to see if there's some reference to it in there.
Now, I understand that your lawsuit's well taken. I think that Alliance City Council is prepared to make the change that you're asking for. Does that mean, if that's the case, if that proves to be the case, does that mean that the lawsuit's going to go away, or no, that you're insisting on taking it right through to the end? What's your assessment to that?
I think my assessment to that would be based upon what official information I received back from the other side, and I assume Law Director Jennifer Arnold will be responding. I've not heard anything from the law director in terms I've read just things in the paper, but that's not something official that someone would respond, with a court filing or anything like that. So I think it's most prudent for me to wait to see what response I get from the law director. This action was filed only about a week ago, a little less than a week ago, and in a number of days, it wouldn't surprise me that she hasn't maybe not even had an opportunity to start to draft her response to this. And of course, professional courtesy and under the rules of procedure, they have 28 days in which to respond to the allegations of a complaint. And so I'm going to, of course, they're entitled to that. And so I'll wait to respond to specifically anything that they have in reply to the allegations of the lawsuit, any communications I received directly from them. So I think it'd be most prudent for me to wait to see how they respond to the complaint.
But you're open to discussing settlement. Is that fair to say?
I think every attorney needs to be open to discussing settlement for every case. As a general principle, most attorneys are willing to negotiate on behalf of the cause that they represent. I can't say what that would be in this particular case because I haven't gotten any communication from the other side yet, and I have to respect the time that they need to be able to discuss what they're going to do, and you have to give them that opportunity.
Now, part of your complaint is asking for damages.
That's correct.
I think the statute provides for damages, at $500 per incident?
That's correct. The statute, the law of Ohio, provides for a $500 civil, what they call a civil forfeiture for each violation. And so since there are 2 violations, I've requested that forfeiture for each violation.
How important is that to you?
Well, I think it's important. It's important enough that the state of Ohio and the General Assembly put it in the statute. I think that reflects the seriousness of what the public policy and the law of the state of Ohio is, which is that we want to have, it's the public policy of this state to have open meetings at all times. And if there's a violation, the General Assembly thought that it's important enough to have some type of civil forfeiture as a penalty for that type of a violation. So I think it is important.
Okay. And you're asking for attorney's fees?
That's correct.
Now, I've had an attorney that's not connected to anybody in this case, as far as I know, tell me that because you file what we lawyers call pro se,
yes,
would not be entitled to attorney's fees. Do you have an answer to that?
If that's an issue that comes up, we'll certainly research it and take a look at it. But the statute does provide for attorney's fees, and so I included it as well in the lawsuit.
Okay. Well, thank you, Steve Okey, for sitting down with us. And before I turn the camera off, is there any matter that I didn't bring up that you would like to address and expound on?
I think you've asked a number of good questions. I appreciate you making the time so that this issue can be heard in the public forum.
Okay. Thank you.